Welcome to the Deep Dive. Today we're tackling, well, a pretty challenging set of ideas, looking at some core sources to get you properly informed on something foundational to Western law.
We really are. We're heading straight into, let's call it the darker side of ancient justice, specifically Athens.
That's right, we're looking at their legal system and a really truly bizarre contradiction in how they tried to find the truth.
A contradiction that honestly shaped everything.
So our mission today, figure out what happens when a society, even a famous one like Athens, needs to guarantee truth in court, but they don't have, DNA testing or security cameras.
It's the age-old problem, isn't it? How do you know if a witness is telling the truth?
And the Athenian answer.
Well,
this is the hook, really.
Yeah.
It's this incredibly stark double standard. It tells you everything about status back then.
It really does. So picture this. You have a free Athenian citizen. They give testimony, voluntarily, under oath, sacred promises.
You'd think that's the gold standard, right? But, and this is where our sources just floor you, even that solemn oath, often seen as, well, not quite enough, maybe even suspect.
Now, flip that entirely. Think about a slave. Their testimony. Legally speaking, it was only valid, only admissible in court if it was gotten through torture.
Let that sink in. The free citizen's sworn word might not be good enough, but a slave's word, forced out by pain, that was considered reliable evidence.
It's an absolutely extraordinary and frankly terrible legal logic. It turns everything we assume on its head.
We'd assume the respected citizen's word carries the most weight. But no, the Athenian system effectively said, your oath is fine, citizen, up to a point. But the body of a slave under duress, that gives us something solid.
And it wasn't some, hidden, shameful thing they did occasionally. The sources, like the historian Gibbon, really emphasize this.
Right. Gibbon points out how Roman officials later on were kind of shocked to find this practice firmly established.
Yeah, established even among the sage Athenians, as he put it, the very people who championed human dignity.
It's a massive historical paradox. The birthplace of democracy and philosophy builds its legal truth-finding on institutionalized cruelty.
And the system had to justify this, didn't it? There had to be a rationale.
There was. A grim one. It's rooted in this deep assumption about what it meant to be a slave.
The Athenian court essentially believed that a slave, by their very nature, their status, was predisposed to lie.
Why? Out of loyalty to their master, maybe?
Yeah.
Self-preservation?
Both, probably. Or maybe just because, in the eyes of the law, they lacked inherent honor, that quality a citizen supposedly possessed. So their default setting was untrustworthy.
So the law needed something to counteract that assumed untrustworthiness, a physical guarantee.
Exactly. The idea was that only the fear of intense physical pain, the rack, the whip, whatever they used, could overcome a slave's natural tendency to lie or protect their master.
Pain becomes the mechanism for objectivity. It's horrifying logic.
And the result, it turned legal proceedings into this bizarre, formal spectacle. It wasn't just about witnesses.
You mean the challenges?
Yeah.
The proklaisis.
Precisely. Litigants would formally challenge their opponents in court. Hand over your slave, they'd say, so we can torture them for evidence.
And if the owner refused?
That refusal itself could be used against them. It could imply they were hiding something, that the slave's testimony would incriminate them.
So it's not just a technique. It's a baked-in legal procedure, a way to generate truth by first defining an entire class of people as fundamentally unreliable.
Unless subjected to violence, their bodies become tools for the court, but only under duress.
And that definition, that legal othering, that's really what we're diving into today, isn't it? Using this Athenian practice to understand this wider legal split, this formal inequality across the ancient world.
Yeah, Athens, Rome. This wasn't unique, sadly. It reveals something fundamental about how they saw society and the law.
Okay, let's unpack this then.
Yeah.
Because you can't have two standards for truth without having two legally distinct kinds of people. How did Athens make that distinction so absolute?
Oh, the gap was enormous. Being a polites, a full citizen versus everyone else. It wasn't just about voting. It was about your fundamental legal standing, your personhood.
Citizenship was precious then, something fiercely guarded. You mentioned the Periclean law earlier.
Right, the law from 451 BC, that was a game changer. It really tightened the definition of who counted as Athenian.
Before that, it was generally just needing a citizen father, wasn't it?
Mostly, yes. But Pericles' law upped the requirements significantly. Both your father and your mother's father had to be citizens.
Yeah, it narrows the field considerably. It really emphasizes this insider versus outsider dynamic.
And that was crucial in a place like Athens. You have to remember, it was a huge trading hub, packed,
full of people who weren't citizens. Slaves, obviously, a massive population, but also
Emetics, resident aliens, often wealthy, crucial to the economy, maybe living there for generations, but legally distinct, lacking full rights.
so the citizen group was actually quite exclusive, a privileged legal minority in a way.
Absolutely. And this exclusivity fed into a whole hierarchy of human value. It wasn't just legal, it was philosophical almost.
You're thinking of that famous quote, the one attributed to Socrates.
Exactly. Where he supposedly thanks the gods he was born, first, a human, not an animal,
Then a man and not a woman.
and finally, a Greek and not a barbarian. It perfectly captures those nested layers of perceived superiority and exclusion. Being a free, male, Greek, Athenian citizen was the absolute pinnacle.
And everyone else, women, foreigners, medics, slaves, existed on these descending tiers of legal status and, frankly, vulnerability.
Precisely, and the law reflected this. The protections given to citizens were significant. Davy Phillips talks about this.
Right, how for citizens, Athenian law was deeply concerned with these complex social ideas like philia, friendship, alliances.
And ecthra-enmity, feuds. It was a system built around personal honor, social ties, reputation. An insult wasn't just rude, it could be a legal injury.
The citizen was a recognized player in this social and legal game. Their body, their person, was considered, well, almost sacred, to use the later Roman term.
It really was held in incredibly high regard, so much so that their individual agency had immense power, even in the most serious situations.
Like in homicide cases, that's where you see this astonishing power of aphiemi.
Yes, it's mind-blowing. The sources suggest that if a homicide victim, before dying, or perhaps through their family afterwards, but before conviction,
If they absolve the killer.
they could, using that word aphiemi, I release, or I absolve, and that absolution could apparently free the killer from all consequences, including execution.
Think about that. The victim's personal word, their forgiveness, could override the state's entire process for punishment.
It shows the incredible weight placed on the citizen's agency, their honor, their individual standing. Their private will could, in effect, trump public justice.
But for a slave or a medic, they were completely outside this system of reciprocal honor and legal agency.
Totally outside. For them, the state's concern wasn't about their philia or ecthra. It shifted immediately to, utility, extraction of information.
Their bodies weren't sacred spaces in the same way. They were potential sources of evidence, instruments.
Which brings us back to that core question you touched on. If the citizen's oath wasn't always enough, why not just torture the citizen too? Why reserve that only for the slave, whose forced word was then considered gold?
It really exposes the fundamental bias, doesn't it? The system presumes something different about the nature of a citizen versus a slave.
Absolutely. There was this inherent, almost insurmountable distrust baked into the legal view of anyone in servitude.
A citizen was assumed to have dignitas, honor, reason. They understood oaths. A slave
Was presumed to be the opposite, deceitful by nature, lacking self-ownership, maybe driven only by fear or a blind loyalty that wasn't seen as legitimate.
So the pain was needed to
Right.
purify the testimony,
Yeah.
override the flawed nature.
That seems to be the logic, however twisted. Only the immediate overwhelming fear of the lash or the rack could, in their view, force the true story out, past the slave's inherent untrustworthiness or their master's influence.
Pain as the guarantor of truth. And this thinking wasn't just some Athenian quirk.
Not at all. It permeated the classical world. We see it crystal clear in Roman law, too. The sources there are abundant.
And they show exactly the same pattern, right? Legal status determines your vulnerability to violence.
Precisely. The Romans explicitly called torture the sanguinary mode of examination, and they applied it primarily, almost exclusively, to what they termed servile bodies.
Protecting the citizen's sacred person, as you said, that was paramount.
Unless, and this is key, unless there was already overwhelming evidence of guilt against the citizen. But the default, hands off the citizen body.
So the moment your legal status was defined as servile, or even just low status, even if technically free,
That shield just vanished. Your body became an object for the judicial process, a vessel to be squeezed for information.
and the consequences of being subjected to that, they stuck around, didn't they? Even if you were freed.
Oh, absolutely. Look at the Roman Lex Aliacentia from around 4 AD. It dealt with manumission, the freeing of slaves.
What does it say?
It specifically addressed slaves who had been tortured during an investigation into some crime or misdeed and were perhaps implicated or found guilty through that torture.
Okay, so What happened when they were eventually freed?
Upon manumission, they weren't just free, they were put into a special, degraded legal category. Dedetici.
Dedetici. What did that mean in practice? It sounds ominous.
It was a permanent legal stain. They were free, yes, but without real dignitas. They could never attain full Roman citizenship.
Ever.
And worse, they were legally barred from living anywhere near Rome within 100 miles, the law said, or even in the vicinity of any Roman town. Basically exiled to the fringes.
So the very act of having been tortured, even if it led to your eventual freedom, branded you legally and socially for life.
Exactly. It's staggering.
That's right.
It shows the state wasn't just getting information. It was marking that person as permanently tainted, unreliable, damaged goods in a legal sense. The torture became part of your identity.
Reducing your chances forever. And this line, this distinction between the protected citizen and the vulnerable other, it was fiercely guarded in theory.
In theory, yes. But power corrupts, and distance maybe creates opportunity. Sources mention Roman provincial governors sometimes getting, let's say, creative, stretching their authority, applying the raft not just to slaves, but sometimes to vagrants or plebeian criminals, low-status free people.
So the edges started to blur. It wasn't always strictly citizen versus non-citizen.
Yeah.
Sometimes it was rich versus poor, powerful versus weak.
Precisely. The honestiores, the honorable, the elite versus the tenures, the humble, the lower classes. If you were free but poor and unconnected, your legal protections could become pretty thin pretty quickly.
But there was one situation where all bets were off, where status meant absolutely nothing.
Yes, treason, maestas.
The fatal maxim, as it's sometimes called.
That's where you see the state's ultimate priority laid bare. If you were accused of treason against the emperor or the state itself,
all those carefully constructed legal privileges.
Gone. Just vanished. Didn't matter if you were a senator, a wealthy merchant, a respected citizen. Didn't matter if you were a slave.
Everyone was on the same level.
The exact same ignominious level, as the sources put it. Everyone became potentially subject to torture. Treason was the one crime considered so severe it could temporarily dissolve the entire social and legal hierarchy.
That's incredibly revealing. It proves that status was the shield, and the state reserved the right to remove that shield if it felt threatened enough.
It tells you that, ultimately, the preservation of state power trumped even the most fundamental legal distinctions of personhood. Your sacred person was sacred only as long as you weren't deemed a threat to the system.
Okay, here's where it gets really, really interesting for me. This whole system, from Athens to Rome, it wasn't just random cruelty. It reflects a deep, ingrained legal philosophy.
Absolutely. A philosophy that explicitly links high social status, wealth, power, background with trustworthiness and legal protection.
And in Rome, that concept was crystallized in the idea of dignitas, honor, respectability.
Exactly. Dignitas wasn't just a social nicety. It was the bedrock of legal privilege. It determined whether you were shielded from the worst excesses of the justice system.
Creating that explicit two-tiered structure we talked about, even among free people.
Right. The honestiores, the elite, were generally protected from corporal punishment. Their bodies were respected. Punishments were things like fines, exile, loss of property.
Painful, yes, but preserving bodily integrity. But the tenures, the common folk,
they were legally subject to exposure to the rods, beating, flogging, hard labor. Their lower status meant their bodies were considered, well, more expendable in the eyes of the law.
Which really clashes with the high-minded ideals of Roman justice, doesn't it? You think of Cicero.
Right. Cicero defines aestitia, justice, as uprightness, the very thing that holds society together, that sustains human association.
But who gets included in that human association? That's the kicker.
Precisely. Because this system formally excluded slaves, and often the poor and marginalized free people, from the most basic physical protections that association was supposed to provide, justice, in practice, seemed to operate primarily within the boundaries of the privileged class.
And once you were marked by that lower status or by servitude, it was incredibly hard to shake off. Even freedom didn't wipe the slate clean.
No, the example of the freedman is crucial here. Legally free, but still operating under the shadow of their former status.
Still subject to the reasonable chastisement of their patron, their former master. Reasonable being the operative and probably flexible word.
And their legal recourse was limited. Think about the law of insult, inuria. The Digest, that great collection of Roman legal opinion, gives us a stark example.
Freedmen could only sue their patron for insult if the insult was, what was the term? Gross.
Gross, exactly. And the definition of gross in this context tells you everything.
It meant the kind of treatment usually reserved for slaves, right? Like a
Right.
public whipping or a really severe beating.
Yes. So things that would absolutely constitute injuria if done to a citizen, maybe a slap, a harsh public insult, serious disrespect. Those were considered sort of within the bounds of the patron-freedman relationship. Manageable correction, perhaps.
The legal bar for what constituted an offense against a freedman's dignity was set incredibly low, reflecting their past.
It's a powerful legal statement about how deeply ingrained these status distinctions were. Freedom was granted, but full dignitas, the inviolability of the sacred person, remained elusive. It was tied to birth and wealth.
So we end up with this fundamental paradox, the desire for truth, for certainty in court.
Led these sophisticated legal systems to build violence into their very structure.
The citizen's body, a temple of honor, truth verified by oath. The slave's body, a faulty instrument needing coercion to yield truth.
In trying to solve the problem of proof, they didn't find an objective method. They simply codified their social hierarchy. They decided violence against the low-status body was a necessary path to truth, rather than question if a system built on such inequality could ever find objective truth. What's fascinating here is tracing it back to that Athenian practice we started with, the torture of slaves for testimony. It just lays bare how the whole ancient quest for legal truth was completely tangled up with maintaining a really brutal social order.
Right. The problem of proof was real, undeniably. Without modern forensics, what do you do? But their solution wasn't neutral.
Not at all. They essentially decided legally that low-status people were inherently unreliable. And the fix for that unreliability wasn't investigation, it was pain.
Which gives us the core of this double standard. The slave's body is deceptive by default.
So you need a physical countermeasure, torture, to reveal the real story hidden underneath. Violence becomes a legitimate, even necessary judicial tool, but only when applied to certain bodies defined by their low status.
And the implication for how we understand ancient justice is pretty profound, isn't it? It suggests that these systems, even in sage Athens, tackled the universal challenge of proving facts in court by embedding inequality directly into the rules of evidence.
Truth itself became conditional on who you were. The ultimate privilege wasn't wealth or power, perhaps, but the right to not have your body violated in the pursuit of someone else's truth. The right to possess a sacred person.
And that privilege could be lost. We saw that with treason, but it was the default for the elite. For everyone else, their body was potentially just an object in the legal machine.
It seems, at the end of the day, the Athenian and Roman courts found it easier, or maybe just more socially convenient, to assume the elite were honorable and the non-elite were deceitful.
And that violence was the necessary corrective for that assumed deceit.
So here's the final thought to leave you with. If aistishia justice is about uprightness, about sustaining human community, as Cicero suggested.
But the very process of finding legal truth in that community relies on the routine, sanctioned torture of a whole class of people based simply on who they are.
Was the real goal of the Athenian court and others like it truly justice in the way we might hope? Or was it more about preserving a specific social order, maintaining stability by legally recognizing and enforcing the existing power structures, even if it meant institutionalizing violence?